Most people move into an HOA community expecting a few inconveniences. They expect the occasional complaint about grass height. They expect passive-aggressive emails about trash cans being visible from the street. They expect annual meetings filled with arguments over landscaping budgets and decorative signs. What they do not expect is to become the personal target of someone who treats a volunteer board position like a royal title. When I purchased my house in Willow Creek Estates, I understood exactly what I was getting into. The neighborhood was beautiful. Tree-lined streets curved around small lakes. Every home sat on oversized lots. Property values stayed high because residents generally took care of their homes. The HOA had a reputation for being strict but manageable. At least, that was the reputation before one particular board member decided she wanted absolute control. Her name was Karen Whitmore. The name alone felt almost too perfect. Karen had lived in Willow Creek for nearly 20 years. Over time, she had become one of those people who confused familiarity with authority. She wasn't the HOA president. She wasn't the property manager. She wasn't even the longest-serving board member. Yet somehow she acted as though the entire community existed under her personal supervision. She monitored landscaping. She monitored parking. She monitored holiday decorations. She monitored construction permits. She monitored things that were not even remotely HOA business. Neighbors joked that Karen probably monitored weather patterns if they affected curb appeal. Most people laughed about her behavior. Most people simply ignored her. Unfortunately for Karen, I was not most people. I had moved into the neighborhood roughly 8 months earlier. My house sat on one of the largest lots in the subdivision. The property had previously belonged to a retired utility executive who had passed away several years before. The estate had finally sold the house after extensive probate proceedings. The property attracted my attention because it offered privacy, acreage, and proximity to several business projects I managed. I purchased it without hesitation. The first few months passed peacefully. Then Karen noticed me. The trouble started with a detached garage. The structure had existed on the property for nearly 15 years. It was fully permitted, fully approved, fully documented. Every previous HOA board had accepted it. Every county record reflected it. The structure appeared on surveys, tax assessments, and property maps. There was absolutely nothing controversial about it. Yet Karen somehow decided it violated community standards. The first violation letter arrived in my mailbox during my 3rd month in the neighborhood. The wording was aggressive. The accusations were vague. The demanded corrections made no sense. I assumed it was an administrative mistake. I responded politely. I included county records. I included photographs. I included HOA approval documents dating back more than a decade. I expected the issue to disappear. Instead, Karen doubled down. A second violation notice appeared, then a third, then a fourth. Each notice contained increasingly dramatic language. Each notice threatened escalating fines. Each notice ignored the evidence already submitted. At first, I found the situation irritating. Then it became amusing. Then it became obvious. This was never about compliance. This was about control. Karen had identified someone she believed would eventually surrender. Someone she thought would pay fines simply to avoid conflict. Someone she assumed lacked the time or patience to challenge her. That assumption turned out to be her first major mistake. What Karen didn't know was that my professional life revolved around contracts, regulations, infrastructure assets, and regulatory compliance. Documentation wasn't merely something I appreciated. Documentation was practically a hobby. Every notice received a response. Every accusation received evidence. Every deadline received certified mail. Every interaction created another paper trail. Months passed. The HOA management company quietly began siding with me because the evidence overwhelmingly supported my position. Several board members privately questioned Karen's behavior, yet she continued pushing. People like Karen often reach a point where backing down becomes psychologically impossible. Admitting a mistake would require acknowledging that they were wrong. For someone who built an identity around being right, that possibility felt unbearable. The conflict slowly expanded. Karen began reporting unrelated violations. A garden hose left outside, a utility trailer parked behind a fence, exterior lighting, roof maintenance, landscaping. Every complaint failed. Every complaint collapsed under inspection. Still, she persisted. The neighborhood began noticing. Residents who rarely attended HOA meetings suddenly started showing up. Stories emerged. Apparently, I wasn't the first target. Several homeowners described years of harassment. One family had been fined repeatedly over a mailbox color that matched approved community guidelines. Another resident spent months fighting accusations about unapproved landscaping despite possessing written approvals. A pattern became visible. Karen wasn't enforcing rules. She was creating conflicts. Unfortunately for everyone involved, she had spent years operating without meaningful resistance. That changed during the annual HOA meeting. The meeting began normally. Budget discussions, maintenance reports, reserve studies, the usual topics. Then homeowner comments opened. One resident raised concerns about selective enforcement. Another discussed inconsistent violation notices. A third questioned board transparency. Karen reacted exactly as many expected. Rather than addressing concerns, she became defensive. The room grew tense. Residents exchanged glances. The property manager looked exhausted. Board members appeared uncomfortable. By the end of the evening, Karen's reputation had suffered significant damage. Many homeowners openly criticized her conduct. Several called for procedural reforms. For most reasonable people, that would have been a wake-up call. For Karen, it became a declaration of war. The retaliation began almost immediately. Anonymous complaints appeared. Inspection requests increased. Violation notices multiplied. Yet despite all her efforts, she failed to gain leverage. Everything changed one afternoon when contractors arrived at my property. They weren't performing renovations. They weren't conducting repairs. They were completing scheduled upgrades related to equipment installed near the rear section of my land. The equipment attracted attention because it looked industrial. Fenced areas, electrical components, transformers. Control systems. Most residents barely noticed it because dense landscaping screened the installation from public view. Karen noticed. And once she noticed, curiosity quickly transformed into obsession. Within days, she started demanding documentation. She wanted permits. She wanted approvals. She wanted engineering reports. She wanted access. She wanted explanations. The irony was remarkable because the equipment had existed on the property before I even purchased it. County authorities knew about it. Utility regulators knew about it. Utility companies knew about it. Everything was perfectly legal. Karen simply couldn't tolerate not knowing something. The more information she failed to obtain, the more determined she became. She submitted requests. She contacted agencies. She filed complaints. She attempted investigations. Every effort ended with the same result: nothing. No violations, no issues, no authority. That outcome infuriated her. Neighbors later described watching her drive slowly past my property multiple times per week. She seemed convinced she had discovered some enormous scandal. She just hadn't figured it out yet. Meanwhile, I continued living normally. Work occupied most of my attention. The HOA conflict became background noise, at least until the first truly alarming letter arrived. Unlike previous notices, this one carried unusual language. It referenced utilities. It referenced safety concerns. It referenced potential service interruptions. Most importantly, it suggested that the HOA intended to pursue action affecting electrical access associated with my property. The wording immediately caught my attention, not because it posed a legitimate threat, but because it revealed something dangerous. Karen was no longer chasing cosmetic violations. She was attempting to interfere with infrastructure she clearly did not understand. That crossed a line, a very serious line. I reviewed the letter twice, then 3 times. Then I contacted several people. By the end of the day, multiple phone calls had occurred. Several attorneys received copies. Certain regulatory officials were informed. A few long-time industry contacts received updates. Everyone shared the same reaction: disbelief, not at my concerns, at Karen's apparent recklessness, because if she actually followed through with what she was suggesting, the consequences would extend far beyond a neighborhood dispute, much farther. The next HOA meeting was scheduled for 2 weeks later. Rumors spread throughout the community. Residents sensed something significant was brewing. Karen appeared unusually confident. The property manager looked increasingly nervous. Several board members avoided eye contact whenever the topic surfaced. And while nobody fully understood what was happening, one thing became clear. Karen believed she had finally found a weapon powerful enough to force me into submission. She had no idea she was preparing to make the biggest mistake of her entire HOA career. And when the meeting finally arrived, events would begin moving in a direction she never saw coming. The first public clue would appear in a single document placed on a conference table. A document that revealed exactly what sat behind the trees on my property. And exactly who owned it. The annual meeting room had hosted plenty of arguments over the years. Residents had debated landscaping contracts, pool maintenance budgets, parking regulations, and architectural guidelines. Most disagreements followed a predictable pattern. Voices would rise, frustrations would surface, and eventually some compromise would emerge. This meeting felt different from the moment people started arriving. Small groups formed in the parking lot. Whispers spread through the room. Board members looked uneasy. The property management representatives appeared unusually tense. Even homeowners who normally avoided HOA meetings had decided to attend. Nobody knew exactly what would happen. Everyone knew something was about to happen. Karen arrived with the confidence of someone who believed victory was already secured. For weeks, she had acted as though she possessed information that would finally put an end to the resistance she had encountered. The repeated failures of her previous complaints seemed forgotten. The criticism from residents appeared irrelevant. She carried herself like someone preparing for a public triumph. The meeting began routinely enough. Committee reports came first. Financial updates followed. Maintenance schedules received discussion, yet the room remained distracted. People were waiting. The tension became almost visible. Eventually, the agenda reached homeowner concerns. Karen wasted no time. She launched into a lengthy presentation regarding alleged safety issues involving my property. Photographs appeared on a screen, images of fencing, images of electrical equipment, images of warning signs, images taken from public roads and neighboring properties. The presentation attempted to portray the installation as some kind of mysterious industrial operation hidden inside a residential community. Karen framed everything as a threat, a violation, an unauthorized use of residential land. The more she spoke, the more uncomfortable several board members became. The problem wasn't simply that her accusations lacked evidence. The problem was that she clearly did not understand what she was discussing. Technical terminology was used incorrectly. Regulatory references were inaccurate. Several claims directly contradicted publicly available records. Yet Karen pressed forward. She appeared convinced that confidence could replace expertise. When she finally finished, silence filled the room. Residents looked around uncertainly. Some appeared confused. Others looked amused. Several simply looked exhausted. Then the HOA attorney asked a question. It was a simple question, one that changed the entire atmosphere. The attorney asked whether Karen had verified ownership records before making her presentation. Karen confidently indicated that she had. The attorney then requested the documentation. Karen handed over a folder. The attorney reviewed several pages. The expression on his face changed almost immediately. What followed was perhaps the first moment Karen realized something was wrong. The attorney continued reading, then reading again, then reviewing additional pages. The room remained silent. Finally, he placed the documents on the table. Several board members leaned forward. The property manager stared at the paperwork. Karen looked confused. The confidence she had displayed all evening began fading. Because the ownership records contained information she had either overlooked or failed to understand. The electrical installation wasn't operated by a utility company. It wasn't leased to a utility company. It wasn't managed by a utility company. The installation was privately owned. Specifically, it was owned by an infrastructure company under my control. The room became noticeably quieter. People who had expected another HOA argument suddenly realized they were witnessing something much larger. For years, most residents had assumed the fenced facility behind my property was some forgotten utility asset. Very few people paid attention to it. Even fewer understood its purpose. The reality proved far more interesting. Decades earlier, the region had experienced significant growth. Several commercial developments expanded rapidly. Electrical demand increased. Infrastructure projects followed. One of those projects involved construction of a small distribution substation, strategically located near expanding service areas. The retired executive who previously owned my property had invested heavily in regional infrastructure partnerships. Rather than transferring ownership to a utility provider, certain assets remained under private ownership agreements. Over time, those ownership interests became concentrated. Eventually, through acquisitions, restructuring, and investments, the controlling interest ended up with my company. The substation remained privately owned, legally, properly, fully regulated, fully documented, completely compliant. The revelation stunned the room. Most people had never considered that something as important as a substation could exist under private ownership. Yet it did, and it had for years. Karen's presentation suddenly looked far less impressive. Unfortunately, she wasn't finished. Instead of backing down, she became more aggressive. The realization that her target possessed legitimate ownership only seemed to intensify her determination. She shifted strategies. If she couldn't claim the equipment was unauthorized, she would claim it violated HOA standards. That argument immediately created another problem. The substation predated numerous HOA regulations. Multiple legal agreements existed, county approvals existed, state approvals existed, regulatory filings existed, recorded easements existed. The deeper anyone examined the situation, the stronger my position became. Karen appeared unable to process this reality. Months of obsession had convinced her she was uncovering wrongdoing. Accepting otherwise would mean admitting she had spent enormous time and energy pursuing a fantasy. The meeting slowly unraveled. Questions emerged from residents. Board members requested clarification. The HOA attorney repeatedly advised caution. Every answer seemed to weaken Karen's position further. Then a homeowner raised an unexpected issue. The resident asked whether the HOA even possessed authority to interfere with utility infrastructure. The room grew quiet again, because that question exposed the real danger. The attorney carefully explained that the HOA possessed extremely limited authority regarding infrastructure governed by state and federal regulations. Interference could create legal exposure, significant legal exposure. The board members exchanged worried looks. Several appeared genuinely alarmed. For the first time that evening, Karen looked uncertain. Yet despite the warnings, she continued insisting that action was necessary. She demanded investigations. She demanded enforcement. She demanded restrictions. The more she pushed, the more isolated she became. By the end of the meeting, the atmosphere had completely changed. Instead of questioning me, residents were questioning Karen. Instead of examining my property, people were examining her behavior. Instead of discussing violations, they were discussing liability. The meeting adjourned without any action against me. Most reasonable people would have recognized the outcome. Most reasonable people would have stopped. Karen did neither. Over the next several weeks, she escalated. What nobody understood at the time was that she had quietly begun contacting outside parties. She reached out to contractors. She contacted local agencies. She attempted to persuade people that the HOA possessed authority it simply did not have. Most ignored her. Some refused involvement. Others immediately referred her elsewhere. But eventually she found individuals willing to listen. That was where the situation became dangerous. One morning I received an unusual phone call. The caller represented a contractor. The conversation was brief, professional, careful. The contractor explained that someone claiming to represent the HOA had inquired about disconnecting or restricting electrical service associated with infrastructure on my property. The contractor wanted verification before proceeding further. The moment I heard those details, every concern I had developed over previous months suddenly became very real. Karen wasn't merely complaining anymore. She was actively attempting to interfere with electrical operations, not because of safety concerns, not because of regulations, not because of legitimate authority, because she wanted leverage. The implications were staggering. Even failed attempts could create liability. Unauthorized interference with infrastructure could trigger regulatory investigations, documentation requirements, compliance reviews, potential legal action. What made the situation especially bizarre was that the HOA had absolutely nothing to gain. No benefit existed. No legitimate objective existed. Only personal obsession. I immediately began documenting everything. Phone records, emails, meeting minutes, correspondence, witness statements. Every piece of information was preserved. Attorneys became more involved. Industry contacts received updates. Regulatory agencies quietly received notice regarding potential interference. Nobody panicked, but everyone took the situation seriously. Meanwhile, Karen seemed unaware of the storm forming around her. She continued filing complaints, continued making accusations, continued portraying herself as some kind of community protector. Then came the incident that changed everything. A contractor vehicle appeared near access equipment connected to the substation property. The workers never completed any activity. They never touched critical systems. They never made modifications, because before anything occurred, verification procedures triggered immediate review. Phone calls followed. Questions followed. Documentation requests followed. Within hours, the entire situation collapsed. The contractor learned the truth. The authorization presented to them was worthless. The HOA lacked authority. Karen lacked authority. The requested actions lacked legal foundation. Work stopped instantly. Reports were filed. Records were created. And for the first time, Karen's actions moved beyond neighborhood drama into territory that involved actual consequences. Real professionals had now witnessed what was happening. Real documentation existed. Real evidence existed. The issue could no longer be dismissed as personality conflicts or HOA disagreements. This had become a matter of attempted interference with regulated infrastructure. The response began quietly. No public announcements, no dramatic confrontations, just careful preparation. Evidence accumulated, timelines formed, legal analysis expanded, regulatory interest increased. Karen remained unaware. She continued behaving as though she controlled the situation. The reality was exactly the opposite. For months she had been pulling on a thread. Now the entire fabric was beginning to unravel. The HOA board started receiving information they had never seen before. The management company started asking uncomfortable questions. Insurance representatives became interested. Attorneys reviewed records. And as more facts emerged, one conclusion became impossible to avoid. The greatest threat facing Willow Creek Estates was no longer a supposed violation hidden behind my property. The greatest threat was a board member whose obsession had placed the entire association at risk. The consequences of that realization were about to arrive. And when they did, Karen would discover that the substation was only part of the story. The paper trail she had created over the previous year was about to become far more important than any piece of electrical equipment sitting behind a fence. Because the next phase wouldn't involve power lines. It would involve accountability. The strange thing about people who spend years abusing small amounts of power is that they often become convinced they are untouchable. Every previous victory reinforces the illusion. Every time someone backs down, they become more confident. Every complaint that goes unanswered feels like validation. Every challenge that disappears convinces them they are right. Karen had spent years operating inside that reality. Residents avoided conflict. Neighbors paid fines they didn't owe. Homeowners quietly complied with demands that exceeded HOA authority. Over time, resistance became rare. Consequences became non-existent. The system unintentionally trained her to believe she could do whatever she wanted. That illusion finally ended during the weeks following the contractor incident. The first signs appeared inside the HOA board itself. Board members who had previously tolerated Karen's behavior began distancing themselves. Questions started appearing in official correspondence. Requests for documentation increased. Meeting agendas changed. Topics that had once been ignored suddenly became priorities. The board wanted answers. More importantly, they wanted records. Lots of records. The management company began conducting an internal review. Initially, they focused only on the events surrounding the substation. That review quickly expanded, then expanded again and again. The deeper they looked, the worse things became. Emails surfaced. Violation notices surfaced. Complaint histories surfaced. Patterns emerged. Clear patterns. Numerous enforcement actions appeared inconsistent. Several complaints lacked supporting evidence. Multiple violations seemed directed towards specific homeowners. Documentation frequently reflected Karen's personal opinions rather than actual HOA standards. What had previously looked like isolated incidents suddenly appeared connected. Residents who had remained silent for years began coming forward. Stories accumulated. Evidence accumulated. The board discovered that many homeowners shared remarkably similar experiences. The details varied. The themes remained identical. Selective enforcement, personal targeting, escalation after disagreement, attempts to pressure residents into compliance regardless of actual rules. Each story alone might have been dismissed. Together, they painted a disturbing picture. Meanwhile, the legal side of the situation continued developing. My attorneys maintained regular communication with HOA counsel. Regulatory inquiries progressed quietly. Nobody seemed interested in creating public drama. Everyone appeared focused on understanding exactly what had happened. The facts spoke for themselves. Karen had repeatedly represented authority she did not possess. She had attempted to influence actions involving regulated infrastructure. She had ignored legal advice. She had disregarded warnings. She had continued escalating despite multiple opportunities to stop. Every step existed within documented records. The paper trail was extensive and growing. As pressure mounted, Karen reacted exactly as many expected. She doubled down. Again. The possibility that she had made mistakes never seemed to enter the equation. Instead, she convinced herself that everyone else was wrong. The board was wrong. The attorneys were wrong. The management company was wrong. The residents were wrong. The contractors were wrong. The regulators were wrong. Everyone except Karen. That mindset accelerated her downfall. During a special board meeting called to address ongoing concerns, Karen reportedly spent hours defending actions that became increasingly difficult to justify. Board members asked direct questions, clear questions, simple questions. Most required straightforward answers. Instead, explanations became longer, more complicated, more emotional, less convincing. Several members later described the meeting as the moment they realized the situation was beyond repair. Trust had evaporated. Confidence had disappeared. The association could no longer function while carrying the liability created by Karen's conduct. The next step came quickly. An independent legal review was authorized. Outside counsel examined records, meeting minutes, correspondence, violation histories, contractor communications. The review lasted several weeks. Its conclusions were devastating. While the report avoided dramatic language, its findings left little room for interpretation. Numerous actions exceeded appropriate authority. Governance procedures had been inconsistently followed. Enforcement practices required immediate reform. Additional training was recommended. Policy revisions were recommended. Most importantly, continued exposure existed if corrective action failed to occur. That finding terrified the board, not because of embarrassment, because of money. HOAs fear few things more than liability. Lawsuits cost money. Investigations cost money. Insurance complications cost money. Special assessments cost money. Suddenly, the consequences of tolerating Karen's behavior became impossible to ignore. Residents learned portions of the findings during subsequent meetings. Attendance surged. People who had never participated in community governance started showing up. Many wanted accountability. Others wanted transparency. Everyone wanted answers. The atmosphere had completely changed. Karen was no longer directing the conversation. She was the subject of the conversation. The shift was remarkable. For years, she had controlled narratives through confidence and persistence. Now, documentation controlled the narrative. Facts controlled the narrative. Records controlled the narrative. And records are difficult to argue with. Then came the election. Normally, HOA elections attracted limited attention. Not this one. Campaign discussions filled neighborhood social media groups. Residents exchanged information. Questions circulated. Participation reached levels the community had not seen in years. Many homeowners viewed the election as a referendum on how the neighborhood would be governed moving forward. Voting turnout shattered previous records. The results were decisive. Several incumbents lost their positions. New board members entered with promises of transparency and reform. Karen's seat disappeared. Just like that, years of influence ended in a single evening. No dramatic confrontation occurred. No emotional speeches changed the outcome. The residents simply made their choice, and their choice was clear. For Karen, losing the board position created an immediate problem. Authority had always been the foundation of her influence. Without it, she became just another homeowner. The special access vanished. The ability to direct investigations vanished. The ability to pressure management vanished. The ability to weaponize procedures vanished. The neighborhood slowly adjusted to a different reality. The transformation was noticeable. Violation notices decreased. Communication improved. Board meetings became less confrontational. Residents who had avoided participation began engaging again. Trust slowly returned. Not instantly. Trust never returns instantly. But progress became visible. As for the legal consequences, the outcome proved less dramatic than many residents expected. The HOA's insurance providers became involved, attorneys negotiated, corrective measures were implemented, policies changed, training requirements expanded. Additional safeguards were adopted to prevent similar situations in the future. The association worked hard to demonstrate that Karen's actions did not represent the community as a whole. Those efforts mattered. Eventually, most concerns were resolved without prolonged litigation. The board learned an expensive lesson, but it could have been far more expensive. Much more. Months later, I attended a community event near one of the neighborhood lakes. Families gathered. Children played. Neighbors talked. For the first time since moving into Willow Creek Estates, the atmosphere felt genuinely relaxed. The constant tension had disappeared. The endless complaints had faded. The drama had finally ended. Several residents approached to discuss everything that had happened. Many still seemed amazed by the original revelation. Not the HOA conflict. The substation. People remained fascinated by the fact that a private infrastructure company owned such a critical asset. The irony never stopped being amusing. Karen had spent nearly a year searching for leverage. She believed she had uncovered a vulnerability. She believed she had found something she could use against me. Instead, she accidentally targeted one of the most heavily documented, regulated, and legally protected assets in the entire area. The very thing she thought made me vulnerable ultimately exposed her own misconduct. That irony remained impossible to ignore. Looking back, the story was never really about electricity. It was never about transformers. It was never about substations. It was never even about HOA rules. The story was about what happens when someone becomes obsessed with control. Karen couldn't tolerate uncertainty. She couldn't tolerate opposition. Most importantly, she couldn't tolerate hearing the word no. That obsession pushed her beyond reasonable boundaries, then beyond legal boundaries, then beyond common sense. Every opportunity to stop was ignored. Every warning was dismissed. Every chance to walk away was rejected. Eventually, the consequences arrived. Not because someone sought revenge, not because someone fought back aggressively, because documentation existed, facts existed, evidence existed. The truth simply caught up. In the end, the neighborhood survived. The HOA survived. Property values survived. Community relationships improved. Life moved on. The fenced substation remained exactly where it had always been, quietly operating, quietly serving the region, quietly doing its job. The same job it had performed long before Karen started her crusade, and long after she lost it. Whenever I drive past that section of the property now, I occasionally remember how close a petty HOA dispute came to creating a very serious problem. Then I remember something else. The moment Karen believed she had finally found the perfect weapon. The moment she thought she could threaten my power. The moment she became absolutely convinced she had won. And the moment she discovered that the power she wanted to control belonged to the very person she was trying to intimidate. That was the day her entire campaign began collapsing. Everything that followed was simply gravity taking over. And gravity, unlike HOA politics, applies to everyone equally. The end.